In recent days, legal observers have directed their attention toward a nuanced but significant procedural filing submitted to the court docket concerning former President Donald Trump. While much of the public discourse focuses on loud political declarations, the actual movement within the judicial system suggests a strategic pivot regarding the interpretation of executive protections. According to reports from the courtroom, legal teams are currently debating specific technical definitions that could significantly alter the timeline of ongoing proceedings. The focus has narrowed to the legal concept of official acts and how lower courts must sift through evidence to comply with new appellate guidelines. This is not merely a matter of delay. It is a question of constitutional authority that requires a meticulous document-by-document review. Analysts note that this process, which is inherently slow and methodical by design, creates a natural friction with the approaching election calendar. One specific institutional detail has emerged as a potential bottleneck: the requirement for additional evidentiary hearings to determine the scope of immunity. Legal experts point out that this procedural step, while seemingly minor on paper, practically necessitates a comprehensive review akin to a mini-trial before the actual trial can commence. The uncertainty here lies in how much information the court will allow into the public record during this preliminary phase. Observers are watching closely to see if the prosecution and defense can reach an agreement on the scope of redactions, or if disputes over confidentiality will trigger yet another round of interlocutory appeals. These technical questions are pivotal because they set precedents for how sensitive presidential information is handled in the context of open litigation. Reactions from constitutional scholars have been mixed, reflecting the unprecedented complexity of the situation. Some argue that the rigorous judicial review is essential to preserve the integrity of the presidency, regardless of the occupant. Others express concern that the protracted nature of pretrial motions could push critical rulings into the indeterminate zone post-election. The institutional tension here is palpable. The court system is built on deliberation and the right to appeal, yet the political cycle operates on fixed, immovable deadlines. This incompatibility between legal time and political time is generating a unique stress test for the judges overseeing these matters, who must balance the rights of due process against the public interest in a timely resolution. Furthermore, the interaction between state and federal proceedings adds a layer of logistical complexity. Analysts note that scheduling in one jurisdiction often relies on the availability of the defendant, which is currently constrained by mandatory obligations in other jurisdictions and campaign events. This creates a domino effect where a procedural pause in one case can necessitate the postponement of others. The unresolved question remains: which court takes precedence should direct scheduling conflicts arise? As of now, no unified protocol has been established to navigate such a web of competing legal obligations for an active presidential candidate, leaving observers to rely on fragmented historical precedents for clues on what might happen next. As legal teams prepare for the next phase of arguments, observers are paying particular attention to signals from appellate courts regarding the speed at which they intend to issue mandates. Recent filings suggest that judges are weighing arguments regarding the separation of powers heavily, a theme that extends far beyond the specifics of the current charges. The focus remains on the stability of the institutional process rather than the immediate outcome of any single motion. The legal community awaits clarity on whether the courts will adopt a narrow, case-specific approach, or if they will seek to establish broader guidelines for future interactions between the judiciary and the executive branch. Following the initial developments, attention has immediately shifted to the specific appellate strategies being employed by Donald Trump's legal team. The primary focus currently rests on the interpretation of executive privilege and the scope of presidential immunity, legal concepts that have rarely been tested in this specific context. Defense attorneys argue that the actions in question fall within the outer perimeter of official duties, a classification that would theoretically shield them from standard prosecutorial scrutiny. This argument forces the courts to engage in a complex constitutional analysis before any factual evidence regarding the underlying charges can be presented to a jury. The institutional stakes of this phase are particularly high because the judiciary is being asked to define the boundaries of executive authority for future administrations as well. Legal scholars observe that a ruling in either direction will establish a binding precedent regarding how much legal protection a former president retains after leaving office. Consequently, the appellate courts are moving deliberately, balancing the public interest in a speedy resolution against the necessity of getting these novel constitutional questions right. This tension creates a procedural bottleneck that impacts the broader calendar of the case. Simultaneously, the logistical challenges of managing these proceedings during an active campaign season are becoming increasingly apparent. The court docket is now competing for space with the primary election schedule, creating a unique scenario where courtroom appearances may coincide with critical political events. Observers are closely monitoring how the presiding judges will manage scheduling conflicts, specifically whether campaign activities will be considered valid grounds for postponement. This intersection of legal obligation and political activity presents a stress test for existing protocols regarding the scheduling of high-profile defendants. The mechanism of interlocutory appeals is central to this phase. Usually, defendants must wait until after a conviction to appeal, but claims of immunity allow for immediate review, which automatically pauses the lower court proceedings. In response to these filings, the prosecution has emphasized the principle that no individual is above the law, urging the courts to reject what they characterize as delay tactics. Their filings stress the importance of maintaining public confidence in the judicial system by adhering to standard timelines. However, the defense maintains that the unprecedented nature of the case requires extended periods for discovery and motion practice to ensure due process is rigorously upheld. The central unresolved question at this stage is whether the appellate process will conclude in time for a trial to commence before the general election cycle enters its final phase. There is no statutory deadline compelling the appeals courts to rule by a specific date, leaving the timeline entirely within the discretion of the judiciary. This uncertainty creates a fluid environment where political strategists on all sides must account for multiple potential scenarios, ranging from a pre-election verdict to a postponement that pushes proceedings well into the next year. As the legal teams prepare for oral arguments, the focus turns to the specific questions the judges will ask, which often signal their eventual ruling. The coming weeks are expected to clarify whether the courts will prioritize the constitutional questions of immunity or the procedural requirements of a speedy trial. Observers are now waiting to see which specific appellate panel will be assigned to review these critical motions. As the proceedings transition into a more granular phase of litigation, the analytical focus shifts to the complex procedural mechanisms currently unfolding within the appellate courts. Legal teams representing the former president have initiated a series of motions centering on jurisdictional and constitutional questions, rather than merely the factual disputes of the case. This strategy highlights a critical feature of the U.S. justice system, the right to appeal interlocutory rulings before a trial commences, a process that often extends the timeline of a case significantly. Legal observers note that these maneuvers are not just standard defense tactics, but unprecedented tests of how courts handle a defendant who is actively campaigning for the nation's highest office. Parallel to the courtroom activities, the campaign apparatus is adjusting to accommodate a schedule bifurcated between political rallies and legal filing deadlines. Data from the Federal Election Commission, FEC, reveals a complex allocation of financial resources, with affiliated political action committees, PACs, absorbing substantial legal fees. This introduces a question of financial sustainability that campaign finance analysts are watching closely. The extent to which grassroots donations are being diverted from advertising and ground game organization to cover legal representation costs. While fundraising numbers remain robust, the expenditure structure suggests a campaign operation shouldering dual fiscal responsibilities rarely seen in modern political history. Within the Republican Party infrastructure, the institutional response to these developments remains one of calculated caution. Party leadership and primary challengers, where applicable, have largely focused their rhetoric on procedural grievances or allegations of systemic bias, rather than engaging with the specifics of the charges. This approach allows for the maintenance of support among the base loyal to Trump while keeping a strategic distance from the indeterminate legal outcomes. Polling data continues to indicate a polarization effect. While legal challenges appear to calcify support among core voters, it remains unclear how these developments impact independent voters in swing states who often prioritize economic metrics and social stability over procedural disputes. Another critical factor is the scheduling tension between the judicial branch and the electoral calendar. Judges are tasked with balancing the public's interest in a speedy trial against the defendant's right to adequate preparation time. Every decision to grant a delay or hear a motion for dismissal has the potential to push proceedings closer to or even overlap with pivotal dates, such as Super Tuesday or the National Convention. This temporal uncertainty creates a volatile environment where political strategies must be planned with multiple contingencies dependent entirely on rulings from the bench. Constitutional scholars are also debating the precedents being set regarding executive immunity and the scope of presidential authority. The arguments being presented in court do not just affect the current case, but have the potential to reshape the balance of power between branches of government for decades. Higher courts, potentially reaching the Supreme Court, may be required to intervene to clarify these constitutional boundaries before any final adjudication occurs. This effectively renders the courtroom an arena of equal consequence to the ballot box in shaping the immediate political future. As we look toward the next steps, the most significant open question remains the logistical compatibility of a criminal trial schedule with the rigorous demands of a national presidential campaign. Criminal procedure rules typically mandate the defendant's presence, which conflicts directly with a candidate's need for constant travel. Observers are watching to see if the courts will adopt flexible measures or adhere strictly to standard protocols despite the unique political context. How the judicial system resolves this scheduling conflict serves as the next major indicator of institutional strength and independence. As we look ahead, the convergence of the 2024 election calendar and multiple legal dockets creates a complex logistical and constitutional puzzle. The central dynamic involves the friction between a candidate's need to campaign and a defendant's obligation to appear in court. Legal experts note that every motion filed by the defense team not only addresses specific evidentiary issues, but also impacts the broader timeline. The strategy of seeking delays is a standard legal practice, yet in this specific context, it carries profound political weight. If trials are pushed beyond the November election, the question of whether a sitting president can be prosecuted or if they have the authority to self-pardon moves from theoretical debate to an urgent constitutional crisis. Furthermore, the role of the Supreme Court remains a pivotal factor. Observers are closely watching for rulings regarding presidential immunity and the interpretation of specific statutes used in the indictments. These decisions will establish precedents that extend far beyond the current administration, potentially redefining the scope of executive power for future generations. The High Court's pacing in accepting or rejecting appeals will directly determine whether a verdict is reached before voters cast their ballots. This uncertainty adds a layer of volatility to the electoral landscape, as campaign strategies must remain fluid to adapt to sudden legal developments. Financially, the interplay between legal costs and campaign fundraising is another key metric. Disclosures indicate that a significant portion of political contributions is being allocated to legal defense funds. This phenomenon highlights the unique nature of this candidacy, where legal battles serve as both a liability and a rallying cry for the base. Polling data suggests that while legal developments solidify support among core voters, they introduce hesitation among independent and suburban demographics. The ultimate political question is whether the cumulative weight of these proceedings will expand or contract the candidate's electoral coalition in key swing states. Finally, the institutional resilience of the judiciary is under the microscope. Judges must balance the rights of the accused to a fair trial against the public interest in a speedy resolution. Security protocols for a former president within a criminal court setting present unprecedented logistical challenges for the Secret Service and court marshals. As these procedural gears turn, the world watches to see how the American legal system manages the stress test of prosecuting a leading political figure during an active campaign. The months ahead will likely be defined by a series of procedural rulings that, while technical in nature, will shape the trajectory of the nation's political future.